Hello and welcome back to our tutorial sessions on the law of torts. This is our 5th episode, episode 5. Before we deal with this episode, a quick recap of episode 4. Under our previous episode, episode 4, we treated false imprisonment, where we established that to be successful, you need to prove the act of imprisonment, the unjustifiable elements of that imprisonment, and the directness of the act of the person who caused the imprisonment. We also discussed the principle under awareness of imprisonment. In today's episode, we are going to identify the elements of the tort of malicious prosecution and highlight the major principles you would need to explain when tackling this particular area of tort. So to begin with, what is malicious prosecution? A malicious prosecution is a tort or civil wrong which enables a person who is subject of a groundless or unjustified court proceedings to seek a civil claim for damages against their prosecutor. What must a person prove to be successful in an action of malicious prosecution? Azu Crab CJ, as he then was, in the case of Musa and another versus Limo Wulana and another, and the decision of Mills Odoye, as he then was, in the case of Sodwa alias Sondra and others versus Obeng and others, to succeed, the plaintiff must prove 5 elements, namely that 1. The defendant initiated a prosecution against him. 2. That the criminal proceedings terminated in the plaintiff's favor. And 3. That the defendant undertook or instigated or procured the prosecution with no reasonable or probable cause. And 4. That the defendant acted maliciously. And 5. That the plaintiff suffered damage as a result of the prosecution. Failure to prove any of these essential ingredients will be fatal to the plaintiff's case, as held in Sodwa versus Obeng mentioned earlier. Let's now see how to establish these 5 elements using the applicable principles. Now, to element 1, that the defendant initiated a prosecution against the plaintiff. In Sodwa versus Obeng, Mills and Odoye JSC stated that the requirement is therefore that the plaintiff must establish that the defendant actively instigated the prosecution or was instrumental in getting the proceedings going. If the defendant merely reported the matter to the police, who do their own investigations before charging the plaintiff, the defendant is not liable. Lindley J. in Danby versus Beardsley said, if you knowingly make a false complaint which results in A being prosecuted, the first requirement is satisfied. However, to go with the police and merely pointing a person out is not a basis for establishing the first element. You can see in Chroma versus Foley for more on this point. Nonetheless, where the informant gives false information or tells lies to obtain the prosecution, then that could constitute a basis for proving the first element, as held by the House of Lords in Martin versus Watson. Lastly, Crab JSC in Yeboah versus Boateng made it known that this element is the first duty of the plaintiff in an action for malicious prosecution. Let's look at the second element, that the criminal proceedings terminated in the plaintiff's favor. In Baseby versus Matthews, Matang J said, it is essential to show that the proceedings alleged to be instituted maliciously and without probable cause has terminated in favor of the plaintiff, if from its nature it be capable of such termination. Biles J also says, showing that the prosecution terminated in the plaintiff's favor applies even to convictions for which there was no appeal. Termination in his favor also means that the plaintiff was not convicted of the particular offense preferred against him. So if he is convicted of a lesser offense, proceedings have terminated in his favor, as it were. For instance, convicted for manslaughter instead of murder, or dishonestly receiving instead of stealing. You can see Boiler versus Holder for more on this. Examples of prosecutions that could be terminated in a plaintiff's favor could include the acquittal of the plaintiff on merits of the case, termination where conviction is quashed for technical reasons such as misdirection to the jury by the trial judge, and discontinuance of prosecution by the prosecutor before the verdict. Let's move to element 3. That the defendant undertook or instigated or procured the prosecution with no reasonable or probable cause. The court in Baseby versus Matthews already mentioned defined reasonable and probable cause in the following words: an honest belief in the guilt of the accused based upon reasonable grounds of the existence of a state of circumstances which, assuming them to be true, would reasonably lead any ordinary prudent and cautious man placed in the position of the accuser to the conclusion that the person charged was probably guilty of the crime imputed. In relating Hawkins J. in Hicks versus Faulkner, Cerebral JSC in Sodwa versus Obing also said reasonable and probable cause means an honest belief in the guilt of the accused based upon a full conviction founded upon reasonable grounds of the existence of a state of circumstances which, assuming them to be true, would reasonably lead any ordinary prudent and cautious man placed in the position of the accused to the conclusion that the person charged was probably guilty of the crime imputed. It must be noted that there is a contrast with Hawkins J's position with Lord Denning's part disagreement in Glinsky versus McIver. Also, where the defendant honestly believes in the guilt of the plaintiff owing to loss of memory, it does not amount to want of reasonable or probable cause. Reasonable and probable cause is proven in two ways. Either A, the prosecutor, whether the defendant himself or herself or a surrogate in law, had no honest belief in the plaintiff's probable guilt when he prosecuted him, or B, the prosecutor had such belief that the facts would not lead an ordinarily prudent or cautious person to the conclusion. That is, the plaintiff was rash in his judgment. Accordingly, Lord Atkin also says the proof of reasonableness and probable cause is a question of law and not a question of fact. Let's move on to the fourth element herein. That is, that the defendant acted maliciously. Mills Odoe JSC in Sodwa vs. Obing said, where a genuine complaint is honestly and bona fide laid, the accuser is not considered or deemed to be the prosecutor or the person who had set in law in force so as to render him answerable for malicious prosecution. Note here that the key words to look out for in his decision is the genuineness of the complaint laid honestly in good faith. Accordingly, Lord Devlin in Glinsky versus McIver says malice relates to the prosecutor's motive, other than that of simply instituting prosecution for the purpose of bringing a person to justice. In 2011, the case of Haworth versus Chief Constable of Gwent Constabulary, Ide J., in differentiating reasonable and probable cause from proof of malice said, the question of reasonable or probable cause itself breaks down into two issues which have to be considered in the light of the evidence before the court. The first is generally described as being a subjective question, namely, whether the prosecutor had no honest belief in the relevant charge. The second is that the objective question of whether the circumstances were such that they would lead an ordinary and prudent man to believe in the charge. Sometimes it is possible to infer the absence of an honest belief from the lack of reasonable and probable cause, but not the other way for malice. Malice cannot of itself lead to an inference that reasonable and probable cause was lacking. Thus, although malice may be inferred from want of reasonable cause does not necessarily follow from malice. And as Gleason CJ said in AV New South Wales, malice is a positive requirement to be proven, whereas absence of reasonable or probable cause is a negative requirement. Explaining what is malice, he further said, it suffices to describe malice as acting for purposes other than a proper purpose of instituting criminal proceedings. Here we are to note that it is not that straightforward and simple to prove malice. Moving on to the last element that requires that the plaintiff suffered damage as a result of the prosecution. Being an action on the case, the plaintiff must prove damage as a result of the prosecution to succeed. Chief Justice Holt laid down the heads of damage recognized under this tort in the case of Saville v. Roberts in the following words. He stated, there are three sorts of damages, any one of which is sufficient to support the action for malicious prosecution. A. Damage to his name, that is, necessarily and naturally affects the fair fame of the person if he is accused of scandalous matter. In B, damage of his person where he could lose his life or liberty, that is, if he is, for example, imprisoned. And C, damage to his property if he is made to incur charges and expenses for his defense. Crab CJ in Musa versus Limo Wulana whereof one was accused be scandalous, or damage to one's person as where one was put in danger to lose one's life or liberty, or damage to property as which one was accused. He concluded as follows. The standard should be that whether a reasonable man hearing of the proceedings brought against the plaintiff would, from the view that they were a damaging reflection on his fair fame of the plaintiff. This brings us to the end of our 5th episode. We hope you learned and will join us for our next episode, which will be on the rule in Wilkinson versus Downton. Like, comment, and share this particular episode. Subscribe to this particular channel and tell the people in your circle about what is going on this channel. Thank you very much for your attention, and on to the next episode.